Ladies and gentlemen, Judge Michael.
Zara, what is the business of the day?
Your Lordship, before you adjourned the court in the morning, the prosecution was making submissions about some drama involving the plaintiffs and the defendant. Mr. Ian had just finished reading out the affidavit of Mr. Newton Mwangi.
Thank you, Zara. Mr. Prosecutor, any other issue before Mr. Wang takes over?
Yes, Your Lordship. We have in our possession an interlocutory judgment by a Deputy Registrar, which, in our opinion, is a matter of great public interest, and which I seek leave of court to read it out. In the opinion of the plaintiffs, the rules of natural justice were ignored in a clear case of bias, favoritism, and abuse of power by a judicial officer. It is the duty of this court to ensure such malpractices by some rogue elements sitting pretty at the judiciary are exposed before the case commences. Your Lordship, we cannot ignore the fact that the said judicial officer is an employee of the defendant in case number 166 of 2025 at the Millimani High Court, and hence the need to be more vigilant.
Okay, proceed then.
Thank you, Your Lordship. After the defendant was duly served with the court summons requiring it to enter appearance within 15 days upon being served, it failed to comply with the court order and only sent its memorandum of appearance long past the stipulated time. In adherence to the law, the plaintiffs proceeded to file for interlocutory judgment on 19th of July 2025. It did this through the judiciary's portal. The application was not acted upon. On the 21st of July 2025, the plaintiff sent its emissary, the said Mr. Newton Mwangi, with a hard copy of the application to the court registry, which the registry duly stamped as proof of receipt. On the 24th of July, upon noticing that the application was not being acted upon, the plaintiffs contacted the court registry before which the application was filed to establish why the application was not being acted upon. Upon several follow-ups, the court registrar, One Honourable Sylvia Matari, finally uploaded on Judiciary's CTS the following decision, and I quote, "There is memo of appearance on the CTS filed by the defendant on the 16th of July 2025. Time for filing defence has not lapsed yet. Interlocutory judgment declined." End of quote. Your Lordship, a copy of the Deputy Registrar's decision, which he uploaded on the Judiciary's online portal, is displayed on the screen before this court. Your Lordship, following this unfortunate decision by the Deputy Registrar, the plaintiffs immediately responded by filing the following protest letter objecting to the decision, and I quote, "To the Deputy Registrar, High Court Civil Division, Millimani, Nairobi. Dear Sir to Madam, Case number 166 of 2025, Application for Interlocutory Judgment. The above refers. On behalf of the plaintiffs herein, I would like to object and protest in the strongest terms possible your decision regarding our application for interlocutory judgment on the following grounds. 1. That the matter was filed in court on the 20th day of June 2025. 2. That on 24th day of June 2025, the respondent was duly served with summons to enter appearance, which required it to do so within 15 days from the date of service. 3. That the defendant did not enter appearance or file its defence within the required timeline. It instead filed its memorandum of appearance dated 16th of July 2025 on the 16th of July 2025, which was past the deadline. 4. That as per Order 50, Rule 8 of the Civil Procedure Rules of Service that deals with computation of days, the 15 days are supposed to be reckoned exclusive of the first day of service, but inclusive of the last day of the same. Needless to state, these rules should be well within your knowledge. 5. That going by the above order, as captured in paragraph 3 herein above, the service therefore expired at 1700 hours on the 15th day of July 2025. 6. That unless you have a strange formula for computing time, it is preposterous and outrageous to rule that the defendant had not exhausted and squandered its opportunity to participate in the proceedings. 7. That it is evident from the foregoing that your decision to decline the plaintiff's request for interlocutory judgment, which you dilly-dallied with for days before you finally got the courage to deliver it, was ill-informed and outright perversion and travesty of the law, and hence it stands rejected by the plaintiffs. 8. Be informed that we are aware that there has been a tradition of litigants being made to go through horrendous experiences in the courts arising from serious malpractices, lethargy and misconduct by rogue judicial officers, and this is what we intend to clean up. 9. Be also informed that by doing so, we are not going to hesitate to make use of other oversight and enforcement organs and resources, including the Ethics and Anti-Corruption Commission, to step in and investigate matters like ours, with a view to taking action against judicial officers engaged in unethical conduct. Our call to action. Given the foregoing, I hereby purpose to demand, which I hereby do, that the ruling which you issued on the 24th day of July 2025, declining the request for interlocutory judgment, be expunged from the court records, and the same be looked at afresh in line with the civil procedure rules. Be advised that I expect this to happen immediately. However, should it not happen, the plaintiffs are going to cite you for misconduct, bias, and malpractice. Note also that the plaintiffs are alive to the fact that the respondent is your employer, and hence the temptation to protect it may be your driving agenda. Your employer is not above the law, or would you rather we prove it is not? You have until 25th of July 2025 to put this matter in order. Thank you. Yours faithfully, Paniel Mwara. For the plaintiffs, Your Lordship, the letter was neither responded to, nor was there any evidence that it was acted upon at the close of business on the 25th of July 2025. The plaintiffs then proceeded to file on Judiciary's CTS the following follow-up letter addressed to the Court Registrar, which I read before the court. The Deputy Registrar, High Court Civil Division, Millimani, Nairobi. Dear Sir, Madam, Case number 166 of 2025, Application for Interlocutory Judgment. Our letter dated 24th of July 2025 refers that given that you have ignored, refused and/or neglected to act on our demand, and that the plaintiffs cannot find any specific rule or law that informed your decision to decline the request, we are left to conclude that the decision was informed by a desire to protect your employer, who happens to be the respondent in the matter, and hence we are proceeding to do the following. 1. When this matter comes up for mention on 18th of September 2025, before Justice Professor Sifuna or any other judge who will be presiding over our matter, we shall petition the court to issue an order directing that your decision to decline the request for interlocutory judgment be overturned, and our request for interlocutory judgment be granted. 2. We will cite you for misconduct, malpractice and bias. However, given that your employer to whom the petition against you should be lodged is the defendant in the matter, we will not petition it to take action against yourselves because it lacks the moral authority or spine to take action against you, given our past experience before it. 3. We shall pursue the matter further, demanding that the judge before whom the proceeding will be conducted or mentioned to invite the Ethics and Anti-Corruption Commission to step in and investigate your misconduct, malpractice and bias, with a view of taking appropriate action against you. Be advised that our pursuit for justice is unstoppable, and we be pulling all stops to ensure that we achieve it. We will not engage with you again on this matter. Judges are not above the law, or would you rather we prove it? Be guided accordingly. Thank you, yours faithfully, Paniel Mwara, for the plaintiffs. End of quote. Your Lordship, that is all. Thank you.
Thank you, Mr. Prosecutor, for the presentation. I need the following clarification. In his affidavit, Mr. Paniel stated that Order 50, Rule 8 of the Civil Procedure Rules of Kenya addresses the computation of days when a number of days is prescribed under the rules or by a court order. Please read out the said rule for us.
Much obliged, your lordship. Order 50 Rule 8 of the Civil Procedure, Rules of the High Court of Kenya, which is cast on the screen before us, states as follows, and I quote, "In any case in which any particular number of days not expressed to be clear days is prescribed under these rules, or by an order or direction of the court, the same shall be reckoned exclusively of the first day and inclusively of the last day." End of quote. Your lordship, going by this rule, it is clear the defendant was late in entering appearance because it took 17 days instead of the stipulated 15 days to do so. You can confirm this by computing the days as shown on this year's calendar, which is cast on the screen before us. Those shown in green boxes are the only ones allowed for computation by the rules. Further, Order 51, Rule 7 of the Civil Procedure Rules states as follows, and I quote, "A plaintiff may, without special leave, cause to be served any application or notice of any petition or summons upon any defendant who, having been duly served with a summons to enter an appearance, has failed to appear within the time limited for that purpose." End of quote.
Thank you, Mr. Prosecutor. We are curious to see how the Deputy Registrar, in concluding that the defendant was not time-barred, computed the time. And this brings me to the next phase of these proceedings. Dear members of public, I hereby draw the attention of members of the Judiciary to Regulation 36 of the Judicial Service Code of Conduct and Ethics, which states as follows, and I quote, "A judicial officer shall at all times carry out the duties of the office with impartiality and objectivity in accordance with Articles 10, 27, 73, Clause 2b, and Article 232 of the Constitution, and shall not practice favoritism, nepotism, tribalism, cronyism, religious bias, or engage in corrupt or unethical practices." 2. In the discharge of duty, a judicial officer shall A. Uphold and apply the law, B. Observe fairness and impartiality, and C. Perform the duties of judicial office, including administrative duties impartially, competently, and diligently, without bias. End of quote. The plaintiffs are hereby asked to proceed to file an interlocutory application in the court handling cause number HCCC 166 of 2025 to challenge the decision by the concerned Deputy Registrar, one Ms. Sylvia Motari, and once found culpable, the plaintiffs are urged to petition her employer to take disciplinary action against her, including summary dismissal, for violating the Judicial Code of Conduct, which she swore to uphold. We will keenly be watching the progress with the matter and keeping the public informed. Further, regarding the issue of misconduct by the defendant when the plaintiffs went to serve it with the court summons, this court urges the complainants to proceed to court to demand for compensation for the harassment and humiliation they were subjected to by the defendant, and to demand for special damages and any other relief the court, which will be hearing the matter, shall determine. I wish to remind the rogue judges and judicial officers and staff that this court was established to fight judicial malpractices, and as such, it will pull all stops to achieve its agenda. Lest the public forgets, it is due to the judiciary-sanctioned economic sabotage that the plaintiffs lost a whooping US dollars 56 billion, or Kenya shillings 8 trillion, which they now claim from the judiciary. This court will ensure the plaintiffs get fully compensated as per their demands, and those responsible for such malpractices shamed and punished. There will be no more victims of judicial impunity in Kenya. Mr. Prosecutor, before Mr. Weng takes over, and as it's now our custom, please proceed to share the professional profile of Justice Professor Nixon Sifuna, the judge who has been assigned to preside over cause number HCCCC 166 of 2025, which is before the High Court at Millimani, Nairobi.
Your Lordship, much obliged. According to information posted on Judiciary website, Honorable Justice Nixon Wanyama Sifuna, whose official image is cast on the screen before this court, was born in Bungoma County and appointed Judge of the High Court in year 2022. He served at Millimani, Commercial and Tax Division. His academic and professional qualifications are as follows. He holds a Doctor of Philosophy degree in law from University of the Witwatersrand, Johannesburg, South Africa, a Master of Philosophy degree in law from Moi University, and a Bachelor of Laws degree from the University of Nairobi. No dates are given as to when he was awarded these degrees. Further, according to the Judiciary, Justice Sifuna also holds a postgraduate diploma in law from the Kenya School of Law and was admitted to the bar in 1995. He also holds a certificate in Environmental Impact Assessment and Environmental Audit from Moi University and is a visiting scholar at the Environmental Law Institute, Washington, D.C., USA. Justice Sifuna has also attended training in tax law, insolvency law, and maritime crime. In his teaching career, Justice Sifuna rose through the ranks from being a part-time lecturer to a lecturer, then to a senior lecturer, and eventually to an associate professor at Moi University. He has been an external examiner in several universities and has practiced law for many years. He is registered with NEMA as a lead expert and is a practitioner on environmental impact assessment and environmental audit. Other responsibilities that he has held include being a member at the Anti-Corruption Advisory Committee of Kenya's National Council on the Administration of Justice, NCAJ. In 2022, he was winner of the inaugural Africa Development Bank's Continental Award for Accountability and Integrity. Your Lordship, Justice Sifuna's interests include promoting social justice, constitutionalism, sustainable development, and the rule of law through judicial decisions, research and scholarly publications. That is all, Your Lordship. Thank you.
Very impressive credentials, Mr. Prosecutor. I wish to remind the members of public and the world at large that Judicial Service Code of Conduct and Ethics, which every judge swore to uphold, emphasizes impartiality by requiring judges to perform their duties without favor, bias, or prejudice, and requires them to ensure that their conduct, both in and out of court, enhances public confidence in the judiciary. This principle extends to the very process of decision-making and requires judges to identify and overcome any personal prejudices or predispositions. Further, the code requires judges to recuse themselves if their impartiality could reasonably be questioned due to personal interest, relationship with a party, prior involvement as counsel, or any other sufficient reason. We trust that Justice Sifuna will overcome any temptation of bias or other malpractice against the plaintiffs, given that the defendant is his employer and that the accused judges are his colleagues at work. Alive to such reality, we will play our vigilant role as the plaintiffs prosecute their case. As a reminder to members of the public who are following these proceedings, the case number 166 of 2025 involves the following parties: Skytop Technologies Limited as the first plaintiff, Skytop McCarfix Limited as the second plaintiff, Demascad Limited as the third plaintiff, and Mr. Paniel Muara as the fourth plaintiff. The defendant is the Judicial Service Commission, from which the plaintiffs are demanding a total of $56 billion as compensation for the losses they suffered arising from gross misconduct and injustice visited on them by the defendant's employees who conspired with other accomplices to use the judiciary to unlawfully and maliciously destroy the plaintiff's businesses. The accused judges are Justice Onesmus Macau of the Employment and Labor Relations Court, Lady Justice Linen Dolo, also of the Employment and Labor Relations Court, Justice Matanga Bernard Odongo Manani, also of the Employment and Labor Relations Court, and Justice Byram Ongaya, who is the principal judge of the Employment and Labor Relations Court. Others are Justice Daniel Kio Musinga, who is the president of the Court of Appeal, Justice Gatembu Kairu of the Court of Appeal, Lady Justice Mumbi Ngugi, also of the Court of Appeal, Justice Katharima Eminoti, also of the Court of Appeal, and Justice Paul Gachoka Mwaniki, also of the Court of Appeal. The Chief Justice, Lady Justice Martha Cormay, is also an accused in the matter. Other judicial organs that are the accused in the matter are Judicial Service Commission, several judicial officers and advocates of the High Court of Kenya, Auctioneers Licensing Board, and one Mr. Jovan Karaoke Trading as Moran Auctioneers. As you can see on the screen cast before the court, as you can see from the organogram displayed on the screen cast before the court, the malpractices and injustices visited on the plaintiffs by the named employees is well documented in the plaint on my desk, an image of which is displayed on the screen. This court will soon read out the entire plaint to the members of public and to the entire world, even as we await the court handling the matter to commence its proceedings on 18th September 2025. Mr. Prosecutor, I am informed by a concerned citizen that this court left out Justice Macau's bio when it read out the profiles of other judges named in the matter. The public needs to know who Justice Macau is. Can you please read it out his bio? Ensure to keep his private life out of this.
Much obliged, your lordship. The omission is inadvertent. Here is his bio. According to the judiciary, Justice Onesmus Macau was appointed judge of the ERLC in July 2012. He has served in Mombasa and Nairobi. Before joining the judicial service, Justice Macau practiced law in various law firms before he founded O.N. Macau and Mule Advocates in 1999. He practiced as a certified public secretary, CPS Kenya, and taught law at Daystar University, Management University of Africa, and at Kenya Institute of Management between 2004 and 2012. He founded and served as a member, director, and chairman of several non-governmental organizations in Kenya, including Dove Foundation, Utuni Development Organization, and Kituo Cha Sharia. Justice Macau holds a Masters of Laws in International Trade and Investments from the University of Nairobi, which he was awarded in 2006, a Bachelor of Laws degree from the same university, which he obtained in 1995, and a diploma in laws from the Kenya School of Law in 1996. He was admitted to the role of advocates in 1996. Justice Macau has served as member of board of directors for several high schools and as a church deacon for nearly 2 decades. Your Lordship, according to his profile on Judiciary website as of today, 28th of July 2025, Honourable Justice Onesmus Macau is married to one wife, and I repeat, one wife, and is blessed with 3 children. He is a born-again Christian and enjoys swimming and watching football. That is all, Your Lordship.
Mr. Prosecutor, I am wowed. A toast to Honorable Justice Onesmus Macau for his impeccable credentials. I wish to remind members of the public that it is Justice Onesmus Macau who admitted the process server's sworn affidavit claiming that the first plaintiff, Skytop Technologies Limited, which was the defendant in case number 788 of 2019, was duly served with summons to enter appearance despite evidence showing it was not served, and went ahead to condemn the first plaintiff unheard. And it was his sister judge, Lady Justice Lynette Ndolo, who refused to summon the process server, one Bernard Ngunzi, when the first plaintiff went to court to contest the alleged service of summons. The scheme against the plaintiffs will be unearthed when the proceedings at the High Court commences. In the meantime, our IT resource may now help members of the public to understand the technologies developed by the plaintiffs so they can benefit from them. Mr. Wang, the floor is yours.